Good morning, everyone. My name is Yuval Shany. I'm from the Hebrew University, from the Cyber Law program, and I wish to warmly welcome you on the occasion of the first joint Cyber Law Conference, co-organized by the Haifa University Cyber Center and the Hebrew University Cyber Center. We are very pleased to welcome you, and we look forward to seeing you throughout the day and tomorrow in Haifa. I'll say a few words about the Cyber Law program in Jerusalem, and then a few words about the topic of the conference, the cyber challenges, the challenges presented by cyberspace and cyber activity to international human rights. And then I will turn over to Niva and Amit, who will say a few words as well. So the Cyber Law program at the Hebrew University has been operating now for a year. It is part of a research center that is centered actually in this campus at the School of Computer Science, which is a predominantly technological program. But we have joined forces, the techs and the lawyers, and the criminologists. And we are now actually, we are trying to complement the work by studying the regulatory framework in which cyber operations take place, by studying questions of liability, and by looking into issues relating to enforcement. The center in Jerusalem, the program in Jerusalem, has about just over 30 researchers, half of which are PhD or postdoc fellows, and the others are internal faculty and visiting faculty and affiliated researchers, some of which are here in the audience. With regard to today's topic, I would want to highlight that there has been in recent years increasing attention to the role of international human rights law vis-a-vis cyberspace. The Human Rights Council has adopted a series of resolutions on the matter. So has the General Assembly of the United Nations, predominantly dealing with the right to privacy in a digital age. Very briefly, the main thrust of these resolutions is that the same rights that people have offline must also be protected online, that the internet has to be global, open, and interoperable, that the internet can be an important tool for the development and the exercise of human rights, that states should facilitate access to the internet, and that international cooperation should be aimed at the development of communication facilities and technologies in all countries, that states should address online security concerns in accordance with their international human rights obligations, that there is a need for human rights to underpin internet governance, and that governments should engage with all relevant stakeholders. I would argue that this represents both a normative equivalency approach and also an institutional equivalency approach. And I, for one, have some doubts as to whether this approach in itself can be sustainable in the long run, given the fact that the cyberspace generates unique challenges for human rights protections, introduces unique risks, and also raises some idiosyncratic issues that would require the development of new concepts about human rights. So just very briefly, there are questions relating to the speed and ease of access to online information, which raises unique set of challenges. There are issues relating to the unlimited duration and effortless access to such information and to online profiles. Which raises strong interest in controlling such profiles. There are also, as indicated, new security risks, and As indicated before, there are particular sets of interest, and I think the challenge for us is in this conference is to see to what extent should the application of international human rights in cyberspace should be more of the same, or should be simply an extrapolation of the online world, and to what extent do we need to think about new concepts. I want to highlight in particular the issue of institutional governance. I think the offline human rights world is very much state-centered. I think the online human rights governance must be very differently configured, given the fact that states have a very limited degree of control over the needs and interests of individuals over cyberspace. Hence, the current focus of the General Assembly resolutions that call on states to regulate internet companies, and through such regulation to ensure the protection of human rights. This approach may only assist us to some extent. It would not address the specific problems relating to the power relations between private actors and public actors, the gap in technological capacity, and the territorialized dimensions of internet and cyber activity. So this is, of course, a very rough sketch of a more dense paper, which I have written on this, and I would be happy to have the opportunity to discuss throughout this conference and in other occasions as well. So I will stop here, and I will now revert to my partners in organization of this conference. Before doing this, I would like to thank very much the team of center staff that has worked to facilitate this conference. So Dr. Tamar Berenblum, our academic coordinator, Noah Sayag and Yael on the Hebrew University side, and Yoni and Lily on the Haifa side. Thank you very much for all of your hard work. I have two housekeeping announcements. We are a guest of the International Institute for Advanced Studies. They have asked us not to, so this is a foodless venue, so they've asked us not to introduce food and drink into this lecture hall. We are recording this session, so beware. And please use the mic whenever you are speaking, so that we could actually capture your interventions. So on that note of caution, I will now surrender the floor to Niva.
Thank you for telling me that we are under mass surveillance even in this event. I guess everyone can still speak openly, and we can use the Chatham Rule House for every use of everything that is said within this meeting, so we can allow everyone to have like an open discussion. Good morning, everyone. Welcome. It's a great pleasure to welcome you here in Jerusalem, and also it would be great to welcome you tomorrow at our Center for Cyber Law and Policy at the University of Haifa. And we're very happy to have this collaboration with Hebrew University. And this is the first of joint events between the sister centers, both of which were created in collaboration with the Israeli Cyber Bureau, on which you'll hear from Amit in a few minutes. And rather than talking about the Center for Cyber Law and Policy, and again, I hope all of you tomorrow will have the opportunity to learn more about it, I think I'd like to say a few words about the challenges as I see them in the 2 days of conference that are ahead of us. And so you can sense, some of the value of having the two centers organizing this, and the type of synergy that we can gain from this type of collaboration. So while Yuval talked a lot about the focus of, talked about the state, the role of the state and the role of international treaties, the focus of our research at the Center for Cyber Law and Policy at the University of Haifa is more on the technology and the synergy between technologists and lawyers in creating new solutions for some of the challenges that we are facing, rather than looking at the states, looking at solutions bottom up as they could be, so as law not only being challenged by technology, but can also inform a conversation with people that are actually designing the architecture. And can help us both provide solutions and not only challenges for some of our legal institutions. And so when I think about cyber and human rights, of course, or the challenges to human rights are as probably ancient as humanity itself. But cyber challenges are creating a new type of challenges, but also create some urgency in this moment of history where we're at. And it's not just that we're facing major technological leaps that and that the pace of change is creating a new type of challenge. So a few of the challenges that we are talking about are the artificial intelligence, machine learning, big data that enable us to shift a lot of the decisions, not just in market and individual behavior, but also in governance itself. The introduction of the Internet of Things and the shift to robotics that actually takes all of the issues and challenges that we were facing in Internet of content and information into the physical space, and some of the technological challenges that are creating by the use of the Internet as a weapon in some cases, and requires some defensive approach and the introduction of cyber wars. So technological changes are creating a lot of opportunities, but also a lot of new vulnerabilities, and that are required to be addressed. And at the same time, and that links to the moment of history of where we're at, there are lots of political changes. Some are not related to technology, I would say. I know that a lot of people are happy to blame some of these, all of the political challenges that we are facing nowadays on technology, but most of them probably are not related, such as the comeback of nationalist policies, the comeback of the new old Cold War totalitarian regimes. But some are linked. For instance, the use of surveillance against journalists and activists, the useful or effective, more effective use of censorship online, something that we haven't seen in the 90s, and we see a lot more today, not just in totalitarian regimes, but also a call for censorship of the internet in liberal democracies, or what we like to call liberal democracies. Altogether, these political changes are marking the decline of and weakening of a lot of our liberal values. So technology is not to be blamed for all of this, but it's definitely creating it's weakening some of our social cohesion and enabling a lot of new phenomena, such as the use of our, for instance, just as an example, the use of our digital environment in a strategic way by some strategic players in a way that actually intervene in our democratic process. So I'd like to actually go back to law and to some of the challenges that we want to address in the next 2 days, and that is the way in which lawyers can actually play a role, not just technologists, but also lawyers. And I think that when it's really easy for us lawyers and policymakers to blame it on technology, some should be blamed on us. And on our way of approaching new problems with some of our old tools, and being reluctant to develop some new tools and new approaches to some of these new challenges. And here, when we think about some of the measures that we use in order to ensure civil rights in the old regime, right, without new technologies, we thought, for instance, of probable cause as something that can protect innocent suspects from invading their privacy. Or but when we think of a world where we use big data and data analytics, that is no longer useful. It's no longer useful because we need to collect all of the information about everyone in order to identify who is a suspect. So therefore, we need to find some new tools in order to address this. Probable cause is no longer useful in this context. So when we think about censorship, right? So for censorship, we had First Amendment and some assurances for securing freedom of speech. But when speech is not blocked in the same way the censorship used to work, but instead there is manipulation of discourse that is done both by private actors, by non-state actors, and also by state actors, as we've seen or allegedly seen in the recent elections in the United States. The manipulation of discourse is a strategic threat on democratic values that we cannot address with freedom of speech. And we need to reconcile with freedom of speech. And for that purpose, we need to develop new types of institutions, new types of processes, and new types of rights, maybe, that would articulate this type of threat and come up with new types of balances. This is what I see as a challenge for the next 2 days, mapping some of the problems, addressing the difference from and the gaps between the tools that we already have and some of the tools that are necessary to address them, and try to think openly and innovatively about new types of solutions in law, but also in norms and technological design. I'd like to thank you for this partnership, and you for this, so now I'm in the middle, and the government for this, for the Cyber Bureau for this partnership, and also to the team in Jerusalem, and to our executive director, Yoni Har-Carmel at the University of Haifa, and project manager, Lily Fay-Bishor, that helped put this together. And I'm looking forward to welcoming you again tomorrow at Haifa.
Thank you. Good morning. It is an honor to speak both after Yuval and Niva about this issue. I'm on the behalf of the sponsor, but also on behalf of the client of this discussions. The National Cyber Bureau set up the joint research centers exactly to have the discussion that we've had Niva and Yuval alluded to, in order to examine some of the concepts and legal mechanisms that we have to deal with the challenges up ahead. And in this context, the fusion between looking at the public international law and the way it applies to states, and the domestic lessons we've learned in the relationship, I would say complex relationship between law and technology and institutions is very important, and I think there is a lot of room here for further development. For my formal role in the state usually has the monopoly on the use of force, and it also has the monopoly on the use of legislation. So the state now is being called to action in both of these areas because of the challenges that we're seeing across the board in diverse attacks on private infrastructure, which has disturbing effects, and policymakers want to do something. And some may observe that states are not doing anything, but I think that it's not because they don't want to, it's because they need the right tool set. and they're very cautious because this is not a natural domain. It is a private domain made up of organizations and their networks. And if there's anything we have learned over these years is that the government's intervention there should be cautious. And in Israel, we've tried to untangle this problem, both on the institutional level and on the legal level. We see a difference between what the government does to protect the infrastructure and its safe functioning and other functions of government, which we have already. And I think this is a core element in which there is, I would say, a complementary mission between human rights and cybersecurity. If we get our balances and institutions together correctly, then cybersecurity helps protect human rights because it helps protect the infrastructure to, in infrastructure I mean the networks and both of organizations, private and public, to function correctly and then enable human activity which happens over the top, which is a different type of discussion. And in our model, we've set up a new sole purpose institution that is tasked with the interface with the private sector in order to do both the ex ante work of making organizations more robust and resilient and also assist them when bad things happen, and they do happen, in a I would say balanced and proportional, this is constitutional law in Israel, not public international law, proportional manner, taking into account risks. When we do the exercise of functional equivalence, which is a term of art from law and technology, and what Niva alluded to, when we look at the risks on the ground, we may see that in many situations when we can create a net positive social solution, because we can untangle the role of the state as provider of security and public safety in the context of the cyber domain, and other interests the state may have in content of communications as described. And these roles can be delineated institutionally and legally. And it's a different type of legal balance to be carried out here. Of course, in order to do this correctly, or in a professional manner, we need an interdisciplinary discussion, because if we don't understand both the empirical facts, what's going on, and the technological expertise facts, which are also important here for legal interpretation, we will get our legal solutions wrong. So this is another reason why we think this type of interdisciplinary discussion is so important. And finally, again, we need to re-examine the relationship between the state and private organizations, which are almost state-like in the way they shape and affect our digital citizenship. And this is a very tricky issue. And over the years, we've seen it first, the laissez-faire type approach of Western countries. And then there is some pushback against it. We're seeing it in the EU with the application of information privacy. But this pushback has been, for my at least reflection, has been stalled a bit because of what we've learned about what states do in this domain. And this discussion is making the issues a bit more tricky. But here again is a role for academics to, I would say, diffuse some of the issues and describe them in a more accurate manner in order to enable us to move forward with net positive legal frameworks that can help us create a stable and secure cyber domain, having a role for the government, having a role for private corporations, and eventually, of course, enabling our citizens to fulfill their human rights and protect free speech and privacy. So I'm very happy to be here and say these things on behalf of the government, because we see this type of discussion as an essential element, because nobody has the monopoly on knowledge and truth, and these types of discussions, even though we may disagree, help us crystallize the problems we should deal with moving forward. Thank you.